All right, I got this question on Quora. Do you hire a lawyer or an attorney to aid in the trademarking process? I'm Andrei Mincov, the founder of Trademark Factory, and here's my answer to this question. I remember this sketch by a Russian comic that I really used to like. It goes about like this. So a patient comes to a Soviet hospital and tells them that, what ails him. And the person at the reception says that the doctor that usually treats patients like this is not there. He will be there tomorrow. And the patient says, well, can I see somebody else? And the receptionist said, sure you can. And said, great. Can I see them now? Well, typically you would want to wait. You would have to wait. They say usually the wait is about 2 hours, but if you want, you can see them now. Okay. And he goes, what do I need to do to see them now? She says, usually you would have to pay the personnel, you would have to bring your own blankets, you'd have to bring your own food, you'd want to bring some flowers to the nurse. But if you don't want, you don't have to do any of that. And this guy goes like, so I'm not really sure what this means. And the receptionist goes, well, if you want my recommendation, I would wait until tomorrow, till the doctor comes in. I would bring your blanket, I would bring the flowers, I would pay the personnel, I would do all of those things that I mentioned. But that's what I would do. Really, if you don't want to do that, if you want somebody else to see you right now, you don't want to pay, you don't have the flowers, you don't have the blanket, you don't have the food, you can just go in and have everything done for you. And you could certainly do that if you're not really interested in the end result. So with trademarks, it's pretty much the same thing, right? Do you need to hire an attorney to get your trademark registered? No, but would I suggest that you do? Probably. If you're interested in the end result, I would suggest that you use somebody who knows what they're doing. All right, I got this question on Quora. If I have a trademark on something, can I make someone give up their username that contains my trademark? Maybe. Sometimes. Really depends on a few things. First, it depends on how unique your trademark is. Second, it depends on how related is your trademark in terms of your products and services that it covers with what that person does under their username. If they do pretty much the same thing as you do and you have a trademark and they don't, your chances go up. Similar with uniqueness of the trademark. If you got a unique trademark and they have the same username, the chances of you being able to force them out of their username are higher compared to when it's some sort of a generic name. Pro accounting. That would be more difficult to enforce. And third thing is the time. Who got which asset first? If they got their username before you even started doing something with it, then even though you got your trademark, you wouldn't be able to do anything about it. But you can't force the platform to give you the username, even if you have a trademark, but your trademark is after they started using their name as their username. So there's a lot of moving parts here, and what you want to do is you want to build a case. You want to build a story really that shows that you are well known under this particular brand, and then this other person is trying to copy you. They're trying to pretend that they are you and that you are them. So if you could paint that picture for the platform that shows that they are the ones who are ripping you off, then yes, of course, you'd be able to use your trademark. If it's the other way around, if they will create a picture of, in fact, we've owned this username for 7 years, and this newcomer thinks that they can just go get a trademark and steal our username from us, that's not going to work. So, which is why I said it depends. So look at those things, look at those factors, and just go from there. Here's a question I got on Quora. Can I register a trademark that is comprised of ordinary dictionary words? Apple. That's it. It's a pretty short answer to a commonly asked question. Actually, a lot of people ask that. Apple doesn't get more dictionary than that, and it's one of the more valuable trademarks out there. So yes, you can trademark dictionary words, and yes, you can enforce them. So if there's one thing that I always laugh at is if somebody is accused of trademark infringement, they steal some other brand, they do something, and they go after them and they're like, it's just a dictionary word, how could they have trademarked it? Well, you can trademark dictionary words, that's not the problem. It's not about Apple owning the word apple. They're not making a claim to the alphabet, they're not making a claim to the word itself. All they do is they say, we will own this in connection with specific products and services listed in our trademark registration. So don't even start with that argument. Dictionary word or no dictionary word, perfectly okay to be trademarked as long as that is not descriptive, not generic, and not too close to other people's brands. So I got this question on Quora. Getting my rap group logo with text trademarked is way out of my budget. Would it be safe to not get it trademarked and have it only copyrighted? This really depends on how unique is the logo. If all you did is you took the name of your group and wrote it in some commercially available font and said, well, that's the logo, or maybe you colored a couple of letters here and there and say, that's my logo, then could you get it copyrighted? Yes. Would that protection give you anything? Not really. But if you have some really well-designed image, then you could have that protected through copyright. It would still not be anywhere as close, as strong protection as a trademark would be, but it would protect the image itself. Now, there's logos actually is the only area where copyright overlaps with trademarks. So typically, you can't copyright names, right? So if you're trying to protect the name of your band through copyright, that's not going to work. If you're trying to write the name of your band in some fancy font and protect that through copyright, that won't work. What copyright will protect is just the way you designed that name, not the name itself. But the overlap, as I mentioned, is with logos, with true logos. So image, for the sake of the image, for how it looks like, can be protected by copyright. But the use of that image in connection with specific products and services, that is something that only a trademark can protect. So can you get some protection of your logo through copyright? Yes, possibly. So it would stop others from recreating your exact logo and placing it, reproducing it in their own works. There is a place for that. But if you're hoping that other rap bands are not going to come up with something similar, not going to use a similar name, or maybe use a similar script or something like that, if you think that copyright is going to stop them, then not really. It won't. It won't stop them. So really the question you've got to ask yourself is this band a hobby, or is this the business? If it's the hobby, then don't worry about it. Just have fun, play music, have a gig here and there, and if somebody, borrows that name, well, it's okay, I guess. Come up with something else. If this is your business, if this is your profession, if this is how you make money, then you do want to have it done properly, and yes, you do want to get a proper trademark on that band name. Because in the end of the day, the name of the band will become one of its most valuable assets as you become more and more successful, which is why there's so many disputes between band members of famous bands as they break up as to who will end up owning the trademark and who can continue to monetize it. Well, here's a question I got on Quora. Do I have to be a citizen or resident of the jurisdiction in which I am filing a trademark application? I'm just going to go with a short answer, and the short answer is no. You can file your trademark anywhere, regardless of whether you live there, regardless of whether you have business presence there. You can file your trademark regardless. Your residence doesn't matter. All that matters is that you have a genuine intention to use that brand in that jurisdiction, and that's all you need. There is some complexity around filing a Madrid application, international trademark application, which needs to be based on what's called a basic application or originating application that you must file in your home country. But beyond that, you can file applications anywhere you want without ever stepping your foot in that country. Like for example, Trademark Factory, our own brand, we trademarked it in New Zealand. I've never been to New Zealand, but we got a registration for Trademark Factory in New Zealand. Does that make sense? Okay. I hope you found this answer useful. If you did, if you're not subscribed yet, subscribe now. We post these videos every single day. And if you got another question for me, if you want to ask me something that has something to do with brands, something to do with trademarks, something to do with entrepreneurship, ask away. Post a comment below and I'll shoot a video just like this one. And until then, I'll see you in the next video.